Hi guys, it's Kathy. I hope you're doing well. So I took this thing off my microphone and I put this thing on instead. Because Fozzie said it wasn't bad, but it wasn't great. So hopefully this is a little better. We won't get to the end of this today. I can't remember if we get the verdict today or not. We get close. Hi, Fozzie. Mike-O. No, next month. You know, the chainsaw has a better chance of getting playtime than that box does. Because it's nice out. And I need to use my chainsaw. Mike-O. Oh my gosh, guys, guess who saw our members only video? You know the one. You know the towel one. Guess who finally saw it? Ginny. Oh, I wish I was with Ginny when they watched that video. I wish I was with Ginny when they watched that video. I feel so bad now. We didn't just save it. Mike-O, somebody needs your help, Mike-O. I hope you're willing. I hope you're willing to lend a hand. Here, Mike-O, this was for you.
Okay, so you made your med management appointment yesterday, correct?
Yes, I did, sir.
Okay, and you were able to work out transportation to accomplish that?
Yes, I was, sir.
Okay, and you heard your attorney indicate that it's important that you re-engage in mental health counseling.
Yes, sir. Mm-hmm.
Okay. Can you make that a priority just as going for the med management?
Yeah.
Okay, how's transportation working for you?
I have my roommate here that took me yesterday, and I can't ask him to take me again. And what I want to know from the courts, do you have any gas vouchers?
I don't.
Mike-O, the lady needs some gas. You're up, buddy. She's requesting free gas. I have a feeling that you got her covered. Oh, we're back to the drooling again. I think she just wants gas, Nan. Nan, you up too? Okay. Mike-O, pick up Nan on your way. Because she might need a lot of gas. Thank you, Mike-O. You're always willing to step in and help. Oh man, I hope I got this clip right, guys, because I crashed out of sleep after work today trying to get this next two hours. I either got it right or I didn't, but I have a backup of this clip to just in case. Don't worry. It'll be fine. I was about to tell you where we left off yesterday, but I don't remember. What I think we left off yesterday was he had that most excellent officer on the stand. And then I don't remember much more else. But I know this is where we are. So if someone else can bring everybody up to speed, then go for it.
Is that probably here? Yes. Okay. All right. Let's bring the jury in.
Well, Judge, just briefly, sorry, before just a very quick thing. I just want to make sure that we're clear before we start closings that just when parties are arguing count 3, I don't think a proper argument to make to the jury would be that Mr. Henson has to be found not guilty because it says metal chair. And so I just want to make sure that we don't run into that so I don't have to object mid-closing or anything like that.
Mr. Spear, I guess my main thing is I want to know if I were to argue to the jury that the weapon is wrong, would the court's instruction be that the state doesn't have to prove that?
I mean, look at those 6 tiny itsy bitsy little waters. Can't they just give each of them a full size water bottle? Doesn't that look like it costs more to have tiny itsy bitsy little waters like that? I bet you there's a sink right around here somewhere, a water fountain. I don't even know why they have to spend all that money on those tiny little waters.
It's not a fatal variance, because if that would be the ruling, then obviously I won't argue such. But I don't, based off of the case law that was cited yesterday, I haven't found anything to suggest otherwise. Other than I think it goes towards whether the weapon is offensive or not, but I don't know if it changes much in terms of metal versus wood.
And you're
I'm going to start selling individually wrapped potato chips.
position, what is just
Just that obviously the court did not grant a directed verdict allowing the count to exist and go before the jury. I don't think a proper argument would be just because it says metal chair, he has to be found not guilty. Because it is, if the jury finds that it meets the elements, then they can still find him guilty of ag assault.
I think
I just can't make it to the point where I'm buying water. Nope. There are literally sinks every single place I go. Sinks with water in them. So some people in my house sometimes buy water bottles. And I'm like, you're an idiot. I mean, there's a sink right there.
the proper way to go about it would be that since the court already instructs the jury on multiple ways of charging a defendant and charges the jury on that the state must meet every essential element, I think at this point, I can argue that it doesn't meet that essential element. The state can argue that it does meet the essential element, and this jury will be left with the jury charge to determine what the material essential elements are.
I think it's, in my mind, it's how you say it, right? If you say, well, you gotta find him not guilty because they said it was a metal chair. I think that's where Ms. Jackson would have an objection. I think you can say, they don't know what they're talking about. They got this all wrong. They said it was a metal chair. It wasn't a metal chair. If anything, it was a wooden stool. Ladies and gentlemen, they don't know what they're talking about. And if they don't prove their case, then you should acquit the defendant. So I think it's how you say it. If you say, oh, well, if you don't find that it's a metal folding chair, you got to acquit him. I think that may be a step too far. I think you can argue they're wrong about a bunch of stuff. But they're wrong about that. They're saying
Kind of goes towards reasonable doubt or something like that.
yeah, I think so.
Yes, sir.
All right, anything else?
No, Your Honor.
One thing I wanted to, this is just before we get to sentencing, and I don't think, did you find?
Dude, sir, your client has not been found guilty yet. Why are you talking about sentencing?
Never mind. Never mind.
Of course, we're going to have have bifurcated the trial, right? So if the jury were to convict Mr. Hitson of battery under the Family Violence Act, then we're going to have a subsequent mini trial unless y'all work something out about whether he has two prior convictions for family violence.
No mini trials, Judge. We just went over this whole mini situation. We're done with minis. We just want a regular size of everything. No extra large, no mini, even though I bought 4 extra large coffees for today. No, Fozzie. No, I'm not. Are you? And Zach, I'm in Manheim Township, but Warwick Township's water's not bad.
Well, it's battery. That's the way we started this out. So it's not something we got to worry about right now, but it may be something we have to deal with, and perhaps y'all can talk about that once closings are over with while the jury's deliberating about if that comes to pass, how you want to handle that. Does that make sense?
Yes, Judge, we will.
All right, let's bring the jury in. All right, ladies and gentlemen, trust you had a good evening. We're ready to move into the next phase of the trial, which is closing arguments. The state has a burden of proof, so they have the right to open and conclude closing arguments. Ms. Jackson.
Thank you, Your Honor. Ladies and gentlemen, at 14 years of age, Killian Henson was trying to step in and protect Lindsay Schubert from a horrific attack. He wasn't able to. And the result you're left with, and what we're left with, is an injured child and an injured woman. And you're left with a lot of trauma that stems to those two people from these incidents. All the way up until this very trial. You have a 14-year-old child who had to come before 13 strangers and testify against his own father. He, since then, has been trying to pick up the pieces all the way to this very trial, trying to pick up those pieces and tell you what happened. Even after his very own dad tried to convince him to forget and change his testimony before you end this trial. And even after
CJ, are you still here? Because you should stay for this stream. Because in this stream, we are going to do mimosas. You should totally stay.
Lindsay Schubert did change her testimony for this very trial. And so you have a hurt kid, a hurt adult. And then in this trial, we have this defense, this defendant trying to bring you all of these things that we've never heard before. We have things introduced newly like broomstick. Never once was that mentioned before this trial in any of the investigation, in any of the videos, interviews, nowhere. It is mighty convenient to go ahead and bring that up at this point in time when we've never previously heard it. And then you have the actual physical evidence and the actual testimony that was presented to you through this trial that remained the same from the beginning of the investigation. And that all goes and lines up with what this defendant was charged with. And so I want to go through that a little bit right now, and we'll go count by count. So starting off with count one, what Mr. Henson was charged with is aggravated assault under the Family Violence Act. And the state has to prove that in this count, he assaulted another, which was Killian Henson, with his hands. Objects when used offensively against a person are likely to result in strangulation. Likely to is very important there, and we'll come back to that in a moment, by grabbing him by the neck and squeezing. And so that's what the state has to prove to you in count one. And the judge will tell you that to prove aggravated assault, the state has to prove just that Mr. Henson assaulted another person with anything that, when used offensively, is likely to or does result in strangulation. So if it is likely to even result in strangulation,
She wins because her skirt is on point.
Guilty of aggravated assault. And I would submit to you that in this case, grabbing and applying pressure to someone's neck to the point that their voice has changed is likely to, or you may find even did, result in that strangulation. But all the state has to prove is that it is likely to, ladies and gentlemen. The judge will tell you that the legal definition of strangulation means blocking or interfering with another person's normal breathing or blood circulation. And that can be by one or two ways, either applying some sort of pressure to the person's throat or neck or obstructing their nose or mouth. Obviously, we don't have count or number two there. Nobody's saying that anyone obstructed a nose or mouth, but there was that pressure applied to the throat or neck in this case, and that goes to count one. Again, ladies and gentlemen, likely to means everything for count one. With anything that when used defensively is likely to, or even does result in strangulation or a change in that breathing or that pressure being applied to the neck, it is likely to do that. We don't have to actually prove injury. And you'll see that up on the screen. The judge will instruct you that when he's charging you as a jury at the end of closing. Injury does not have to be proved. Now, there's a lot of testimony and medical records from doctors in this case where there were actual injuries. But to be guilty of count one, aggravated assault, even if it was likely to result in strangulation, that's all there needs to be for you to find Mr. Henson guilty of that. There doesn't have to be actual injury.
Your Honor, I'm going to just object just because the indictment is that he grabbed and squeezed his neck. So it's not just that they have to prove that he tried to choke him with anything and then likely resulted in strangulation. The proof would be that he used his hands to grab and squeeze.
I'm going to overrule the objection. Ladies and gentlemen, what the attorneys say in opening, what they say in closing, what they say in objections, what they say in questions is not evidence. You've heard the evidence in the case, and that's what you'll base your decision on, and I'm going to charge you on the law. Go ahead, Ms. Jackson.
And you'll hear that part as part of the charge from the judge coming for the jury instructions here soon in a little bit. The state has to prove that this defendant attempted to cause a violent injury or did something, committed some act that placed that person in apprehension of receiving a violent injury. As it relates to count one, ladies and gentlemen, I would suggest that Mr. Henson's neck around his hand around his 14-year-old child's neck, pressing down on that was certainly likely to impede his breathing in some sort of way, and that he, at the very minimum, attempted to cause an injury or placed Killian in apprehension of receiving an injury. He testified to that he was scared of that and how that affected him. And so that would be the count one that I was speaking to you about, likely to result in strangulation by grabbing Killian Henson by the neck and squeezing or applying that pressure. So what evidence do we have and what was presented to you for count one, that strangulation against Killian? Well, we have him from the very beginning saying, yes, I was grabbed by the neck. And that first screenshot on the left there, that's when Truslow just went out for the first time. He didn't even speak to him. He's sitting there awake. He's literally holding his shoulder, and Truslow didn't speak to him. So, of course, we don't have a statement or an interview from that interaction. Now, the next time that Truslow goes out, you see up there, it's about afternoon on April 16th, and this is what's said.
That involved you as far as you getting hurt?
I was pushing up against the wall, my shoulders bruised up.
What are you doing today, Fozzie, on your day off? Who else has off today? Does anybody else have off today?
He was pushing up against the wall. And then he talks about his shoulder injuries as well from being held up against the wall. What other evidence do we have?
That doesn't hurt at all. Like that doesn't. I can't.
What is that from? Strangling him?
Yeah, when he held me against the wall, he held me by my neck.
Did you tell the other officer that?
He held me against the wall by my neck. Again, he at 14 years old is telling some authority figures, some law enforcement, that he has been held by the neck. Defense counsel wants to make a big deal about the fact that he did not utter the word strangled. He's 14 years old, ladies and gentlemen. What legal terminology are we expecting from a 14-year-old asking for help, saying that he has been hurt? I've spoken to you about what's required under count one. Nowhere is it that someone has to say the word actually strangled, and certainly not at 14 years old. He is describing what is in count one, ladies and gentlemen. We also have testimony about how his neck appeared. Obviously, we have the scratchings that we've seen and that have been tendered in evidence from the necklace being put into his neck from that squeezing. And also we have the testimony about it appeared that there were some finger markings at some point in time around his neck, but definitely the scratching there, as you can see in the photo. Now we also have hospital records. You heard from Dr. Pressler how he talked about that. How Killian said even at the hospital that he was held by the neck. And so at each point of this investigation, a 14-year-old is saying he was held by the neck. And that is count 1, ladies and gentlemen. And that, again, that is the medical records talking about where Killian was held by his neck. And those will go back with you. You'll be able to review that narrative if you wish as well. These, again, are just some of those pictures of the scratchings on his neck. And, of course, the injuries on the back of his shoulder from being held against that wall by the neck. And then the blood on the tank top matching. Count 2. So count 2, same elements. Now we're talking about Lindsay Schubert and whether or not she was strangled. Same elements on this, ladies and gentlemen. Did knowingly make an assault upon the person of Lindsay Schubert with his hands, which when used offensively against the person are likely to result in strangulation by grabbing her by the neck and squeezing. Again, likely to, really important here, the judge will charge you that if you find it's likely to result in strangulation, that is all you need to find Mr. Henson guilty of count 2. What evidence do we have to back up count 2? Well, we have Lindsay's first initial statement to law enforcement. What was that?
Okay, so Kevin, the dad that was here last night, stabbed, I don't know what happened, but he hit me in the head with a stool. My head was bleeding. He tried to choke me out. I'm scared to go in my house. I told him last night he needed to leave, but I don't know if he's here, and that's not the fire station.
This is your
He snapped. He tried to choke me out. The very first thing that she says to law enforcement, right there in that clip. You have testimony from Andrea Gibbons saying, this time he beat the F out of me. You have hospital records where Lindsay went to the hospital that very same day. Up on the screen, you've got that narrative. Not only did she tell law enforcement she was choked, that's her way of saying strangled, choked or strangled, but she went on to the hospital, and you'll get to see these, struck in the head with a stool and was choked. At every turn, she is saying that's what happens. That is the evidence for count 2, ladies and gentlemen. That is also a little bit more of the medical records talking about how Dr. Negrani spoke to you all about the actual injuries that Lindsay had to her neck. Now, again, the state does not have to prove that she was actually injured, but here you kind of do have some injuries. Even though we don't have to prove that, we've got talking about swelling on her neck, and the doctor mentioned that the anterior means that front of her neck, and then also that she had numerous bruises on her face, scalp, and neck. He testified for you all that that indicated there was some real major trauma that had gone on right on her neck, that was indicative of that. And again, likely to result in strangulation. Don't have to prove actual injury, just that that was attempted or that person was in fear of receiving an injury. So count 3. Count 3 is aggravated assault, but it's a little bit different elements just because of how it was charged. So obviously, count 3 talks about her being struck over the head with a metal chair, which when offensively used is likely to result in serious bodily injury by hitting her over the head with that metal chair.
Does hitting someone over the head with a metal chair result in POP issues for the rest of their lives? I'm just wondering, for a friend.
Now, obviously, the evidence in this case came out that it was actually maybe a bar stool or some sort of similar chair. But ladies and gentlemen, what's important to note is that the judge will tell you the elements of aggravated assault on count 3, like I said, we're a little bit different. For this way the aggravated assault is charged, if you find that Ronald Kevin Henson assaulted another person with an offensive weapon, you can find him guilty of aggravated assault. We all are clear and know what happens. I submit to you, ladies and gentlemen, that she was struck over the head. If you find that she was assaulted by him with an offensive weapon and you find a bar stool or a metal chair or whatever that is an offensive weapon, you can find him guilty of count 3. She was very clear. She testified that she was struck over the head at every point in turn in the medical records. At the initial time where she talked to the deputy, she said, I was struck over the head. And so you have that in the hospital records. She testified to it. She talked about it on scene. And then she also told Andrea that she had been struck over the head. So you had sufficient evidence to find him guilty of count 3. Also in count 3, the same sort of logic applies as it did for count 1 and count 2. The judge will tell you, don't have to show actual injury, which of course we know we have injury here in count 3. There was testimony in medical records of actual lacerations on her head. And of course, all of the different bruisings on her body, or contusions, as the doctor called it. Now, an offensive weapon, the judge will tell you that's actually defined as any object really that's likely to cause or does cause death or seriously bodily harm. That's up to you to decide whether a bar stool or a chair or anything is an offensive weapon. That's up for you to decide, and you to use your common sense how that was used and all of the things I presented in this trial, whether or not that was an offensive weapon when somebody was struck over the head with it. Again, Lindsay's first statement to law enforcement.
Okay, so Kevin, the dad that was here last night, stabbed, I don't know what happened, but he hit me in the head with a stool. My head was bleeding. He tried to shut me out. I'm scared to go in my house. I told him last night he needed to leave, but I don't know if he's here. And I stopped at the fire station.
This is your
So her very first statement, I was struck over the head. You also, again, have the narrative from the medical records where she talks of being struck in the head with that stool and was also choked. You'll also have this part of the medical records talking about all of those contusions and also that laceration, which we just discussed, that was on her head about 2 centimeters long from being struck. All right, now we get to counts 4 and 5.
Counts 4 and 5. I just want you guys to all remember, as we're watching this, we still don't know if he's going to be found guilty. We still don't know, because this went to trial, because he could be innocent.
Now, both of those in the indictment are charged as battery. And in count 4 specifically, Mr. Henson is charged with intentionally causing substantial physical harm and visible bodily harm, bruising to the neck and back of Killian by grabbing him by the throat and slamming him against a wall repeatedly. Now, the judge will tell you that the elements that go with that battery charge in this course of conduct in count 4, a person commits the offense of battery when they intentionally cause visible bodily harm to another. What's important to note about a battery charge, ladies and gentlemen, is visible bodily harm. That's what makes a battery charge different from a simple battery charge. And you'll hear the judge instruct about that. So simple battery, you don't even have to see any markings. There doesn't have to be that visible element. And that's what's really important for the battery charge, is there's a visible element of the battery to Killian, of course. Now, we have the photographs and evidence from where we can see the scrapings to his back shoulder and the scratching on his neck. And so that certainly goes to count 4 with that visible element that we were talking about. One thing I want to note for you all, and you'll hear the judge mention this in the charge, is that you'll see in count 4 that the battery is alleged in one of 2 ways. And that is that Mr. Henson caused that visible bodily harm by bruising to the neck and back of Killian, and by grabbing him by the throat and slamming him. But what this charge, and why this charge is important, is because when you see that word "and" in an indictment, the judge will tell you that you are authorized to find either one of those ways, and he can still be guilty of the battery, of course. So just to actually bring that all the way around, count 4, where it talks about bruising to the neck and back defined bruising to the back. That satisfies that part of it. Doesn't have to be neck and back, which of course we have injury to both, but if for some reason you found one or the other, that would still be enough to satisfy count 4. And then likewise, that same logic is going to apply to this part of the count 4, grabbing by the throat and slamming. So if that happened by him grabbing him by the throat, or if that happened by slamming him against the wall, or both, either one is enough to prove that count 4. However you find that in evidence. But again, important to note that visible part there on counts 4 and counts 5 makes it different from a simple battery. Now, what also is important is that word repeatedly. And counsel will talk about that word as well. You could find that Mr. Henson shoved him into the wall by the neck, causing those one time, and he's still guilty of a battery. Repeatedly there is really just surplusage, but honestly, if he did it once, he's guilty of count 4. And if you view Killian's testimony as being picked up and then thrown and then he kind of fell down as repeatedly, you can view it that way as well. Either one, ladies and gentlemen. Count 5. That is the battery count against Lindsay Schubert. Same elements, same logic applies. The judge will charge you on those elements. But what's in count 5 is that visible bodily harm, which was contusions to the face and person of Lindsay by slapping and punching her. Again, that same and or logic applies. When you see that word and, it can be or. The judge will read that to you. So by slapping her it occurred, or by punching her it occurred. If you find that either one of those, she had those contusions which were present in the medical records, you can find that he is guilty of count 5, that battery. And ladies and gentlemen, we have, those are the same elements that I just mentioned to you for count 4. They also apply to count 5. We also have the medical records, which we were talking about, showing all of those contusions around her neck and on her face, and also on her scalp that the doctor spoke to you about yesterday. All of these counts, you probably noticed, they say like aggravated assault, family violence, battery, family violence. They always have that family violence tag. There's nothing too much to get hung up about. The judge will tell you that the definition of family violence is when the occurrence of an aggravated assault, a battery, any of those crimes or simple battery between parents and child living in the same house, that just means family violence under the law. So if it was parent and child, like Killian and Ronald Henson, that's family violence because they're parents and kids. Or folks living in the same household, Lindsay Schubert and Ronald Henson, that's family violence because they're living or formerly living in the same household. Either one of those. One thing I want to talk about, ladies and gentlemen, is you'll hear the judge talk a lot about the state's burden in this case, and we talked about it in Buddy. My burden is to prove this case to you beyond a reasonable doubt. And that means exactly what it says. The doubt of a fair-minded, impartial juror honestly seeking the truth. It's not some vague or arbitrary doubt. It's not some doubt as to something extraneous or extracurricular out there. It's a doubt as to the elements that we just went over. So it's a doubt that would have to be about something in these counts 1 through 5. It's not, hey, I like Lisa Collette, or hey, I like Deputy Trustlow, or anything like that, anything extracurricular. It's literally what is in black and white on this piece of paper. And so I just always want to point that out because sometimes folks get worried without what does that mean? Is that scary? That's some crazy high standard. Well, yeah, but what does it actually mean and what does it apply to is really important to consider. It's to those elements on the indictment and what elements and evidence matches up with what the judge says the law is that we have to prove. That is what you have to pay attention to. It's not beyond all doubt. It's not beyond some mathematical certainty. It's not beyond a shadow of a doubt or anything like that, ladies and gentlemen. In this case, you know what happened from the testimony that happened on this witness stand and from the physical medical records and pictures and all of those documents, evidence, and testimony that I have presented to you through this trial. There will be some discussion about some other offenses on the verdict form, and I'll go through that here in a little bit. You'll see that that's listed off. They're all listed in a line here. But what I really want to urge you to do, what I'm asking you to do, is to find Mr. Henson guilty of the crime that he was actually charged with, not something lesser or some compromised something. What he was actually charged with and what fits in this indictment is what he needs to be held responsible for. And we'll come and talk about that a little bit more, but I just want to go ahead and put that out there so that you can be thinking about that as we go along. The judge will tell you that in evaluating all these folks on both sides who you heard testifying, you yourself as the jury get to evaluate them and determine how you see them however you want to. And that can be from any of those things up there on the screen. I'm not going to read off every single one of those, but long story short is you get to judge these folks, how they testified, and see what you think about them, and determine who might have a motive to lie in this case, who might have testified one way or the other, anything like that that you want to consider, ladies and gentlemen. With Killian, of course, you know, he was 14 at the time, he's 16 now. He has tried to say how he's been hurt from the beginning of this and tell you even to this trial how he's been hurt. And again, even though he didn't use that exact word, strangulation, my goodness, he's a kid. I don't expect him to know all of these legal terms that we all know. The defense tried to talk about that, oh, maybe his cell phone wasn't actually broken or all of that stuff. At each point in time, he told the officers that he didn't have a cell phone because his dad broke his phone. He has been consistent, incredible throughout this trial. Now, Lindsay, she's interesting because, you know, her first statement to law enforcement is, trying to choke me out. And
No, I'm not doing an actual poll, but we can poll. Guilty or not guilty? Let's go. I'm not pressing play until you guys vote. While we're waiting for everybody to vote, let me just tell you about next Monday. Oops. There will be no OJ next Monday. Maybe. Probably. Instead, I'm going to do my 2-hour stream as normal. However, I'm going to have extra content. If you want me to continue after 2 hours next Monday, it's $1 a minute, 10 minutes, $10. You have to send it through a super chat or PayPal. So I will go up to 24 hours next Monday. $1 a minute. Thank you, Fozzie. I couldn't remember what we were talking about because I changed my mind a whole bunch of times. I'm going to go up to a 24-hour stream next Monday. Unless I get too tired, and then I'm not. But I'm going to have enough content ready, maybe, or I'll fake it, for 24 hours of a stream on Monday. But I'm only going to do 2 hours for free. 2 free hours. After that, you have to pay $1 per minute. No, you don't go over 24 hours and I'm going to have plenty of coffee. But who knows? Maybe we'll only do a 2-hour stream. If we do only do a 2-hour stream, then I'll do OJ. That's what's happening on Monday. True. I don't get that, you know. I don't get all that money, you know. YouTube takes almost all of it. All right. We are at guilty, 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 guilty. Here we go. Let's see.
hit him in the head. And then she wants to come in here and say that didn't happen. But what's really interesting is that we have these medical records over here where she told the cops what happened back in 23. Then she went to the doctor because she was trying to get appropriate medical attention and told what actually happened. That's because that's what happened at the time. She's had 2 years to come up with this broomstick story and come in here and feed y'all this, hoping that y'all will bite on it. We know what happened at the time. Judge her credibility. She actually told you she was struck over the head. She's not denying that. That happened. She wants to minimize and create all these extra details that they just aren't. They just aren't there. You hear a lot of talk about Andrea Gibbons, and the defense wants to act like she's just somehow out to get Mr. Henson because she says on there, is he going to go to jail on the body cam? But if you really pay attention, her son's in the background showing the injury to his shoulder. And she looks over there and sees it, and it's like, oh my God. Like, she has an emotional reaction. Like, oh my God, is he going to go to jail when my son is over there hurt? I don't blame her for that. Really look at all the evidence and see if that makes sense, what the defense is saying with what actually was presented on the video, ladies and gentlemen. Now, as far as both of the law enforcement officers that testified in this case, Deputy Treslow,
we cooked today. We cooked mimosas. And I showed you how to make one. There's a big deal with mimosas, okay? Some people think 25% Prosecco and then the rest is juice. Other people go half and half. And then the best camp, which I'm not in, but they are the best, is 25% is juice and the rest is the good stuff. If you want to make a very good mimosa, you take 50-50. 50-50 and you'll be fine. I'm using cranberry today, not orange juice, because I don't want heartburn.
I don't have anything personally against Deputy Treslow. I just think, unfortunately, on this case, he missed it. He missed. And I'm not saying that he's not a good person. I'm not saying that he didn't do good in the military and serve our country and he didn't do good as a law enforcement officer, because I'm sure he did. He's an experienced one, but he missed on this one. And I try to show you through my questioning how he did it. And so judge that credibility. Judge the fact that he said he was going to go follow up on Lindsay at urgent care and never did. Never filled out the strangulation report with the child. Never did any of those things, and how you view that. Judge the manner that these folks had testified in. That also goes to credibility of a witness. So what's interesting is Deputy Treslow is up there testifying, and he's recounting what happened and everything. And I start asking him some questions, and he kind of forgets what's happening until I play the phone calls with Lindsay. And then he remembers, and then he says something that's really interesting, that the defendant tried to reach out to him at some point after the trial. And so that was really interesting in my mind, why that might be. So use that when you're judging the credibility of witnesses. And also the doctors that testified before you, those are just medical professionals. They're just testifying to what's in the documents that you'll have when they saw the folks. Another thing that the judge will tell you in the charge is that there's no legal requirement of corroboration of a witness. So if you believe something that someone says, be it Killian when he said he was held by the neck, be it Lindsay's original statement, there doesn't have to be corroboration. If you believe it, that's sufficient to establish a fact. So just keep that in mind as well. We talked a little bit in voir dire, when folks come to serve on the jury, we're not asking you to leave out your common sense and your life experiences. We're not asking you to do that. Actually asking you to think about what makes sense in a case like this. Why didn't Killian use the word strangulation? Well, because he was 14 and he was trying to say he was grabbed around the neck. What makes sense? What makes sense about why we don't have some of the stuff that the defense asked about? Well, we don't have it because Deputy Treslow didn't go and see Lindsay at urgent care. He didn't take pictures around the house He didn't finish following up with the kid. He didn't go take the appropriate charges that he was talked to about. And so just use your common sense when you're hearing that stuff and think about why does it not exist? All of those things. But in a moment, ladies and gentlemen, I'm going to sit down. Defense is going to have a chance to go ahead and get up here and make their closing remarks to you. And the thing that I want to ask you to do while they're making their remarks is to just consider what's being said and why it's being said. Consider why it's actually being said and how does it line up with what the beginning of this investigation was and what's been presented to you through medical records and picture testimony and live testimony. And because of all of those things, ladies and gentlemen, I'll come back before you, have a few moments just to speak again and tell you what I'm asking for really in this trial. And I'm asking for you to hold Mr. Henson accountable for the actual crimes that he was charged with, not a compromise, not some lesser count, what he's actually responsible for, which is in that indictment, ladies and gentlemen. I submit that you have it in this case, and I would ask you to find him guilty of those counts as charged. Thank you.
Shapiro's going up, not the trainee, guys. Let's go.
Ms. Jackson, you used 32 minutes of your hour.
Yes, Judge.
Actually, no, you're good. I'm just gonna play it on here.
Are you around?
Yeah, that's fine. Can I take your gun?
We'll leave it here.
You know what? Hold on one second.
This is like about, sorry. I think I'm Good morning, ladies and gentlemen. At the beginning of this trial, I told you that you have an indictment in front of you and that something happened on that night, but it was going to be y'all's job to figure out what it was that happened. So our defense has never been in this case that something did not happen. Something did happen, but it's your important duty and job to figure out what that is and whether the state has proved these crimes alleged in this indictment specifically beyond a reasonable doubt. Now, Ms. Jackson said that reasonable doubt is not a scary thing. It's not a crazy high standard. It indeed is a crazy high standard. It may not be to a mathematical certainty, but it means exactly what it says, beyond all reasonable doubt. Beyond reasonable doubt. Like Ms. Jackson said, doubt that cuts against these elements. We'll talk about that in just a minute. But it's y'all's duty to presume Mr. Henson innocent and to acquit him until the state has reached its burden as to these charges. It's a scary thing. Reasonable doubt applies in this country, in this state, to protect everybody's liberty, to protect anybody that is put on trial. So reasonable doubt is indeed a crazy high standard and a very scary idea. It's both of those things. Mr. Henson got into it with Ms. Schubert. I told y'all that. They got into it. The broomstick was not some made up story. Y'all watched, I believe it was the initial body cam of Investigator Treslow when he came out there. And you saw him walk through the home. You saw him go through and walk. And in that video, Ms. Jackson pointed out that he does not take photos of the home. But I submit to y'all that through this video, y'all have every view of the home unique. He goes through the entire home so you can see the kitchen area, you can see the bar stool, you can see the broomstick. These are not made up objects that came out of thin air. These objects are all there. And yes, the shooter never told anybody about the broomstick. That's here.
Oh, guys, so there was a broomstick in her kitchen. So, of course, he's innocent because there's a broomstick in her kitchen. It's not like any of us have a broom in their kitchen.
She did not go out there and talk to anybody. So I'm starting to not understand that idea that you're unhappy with how Truslow handled it, and he resigns a few days later, and then the thing that you were very concerned about, you don't go back out there to interview Ms. Schubert. She had the same capabilities to go look at these medical records, go talk to Ms. Schubert and ask her what happened. She never does that. And so as y'all think about reasonable doubt and things that you have doubt in your mind about, I want y'all to think of some important bullet points. These are just things I jotted down, and anything that came to your attention during trial is fair game. There's no photographs of Lindsay's injuries. That's a problem. You were tendered photographs of Killian's injuries, but you were not given any photographs regarding Lindsay. That doesn't really make sense. And I'll explain to you why it doesn't make sense. I know that Dr. DeGraw is a doctor and that he's a specialist in looking for bruises, harm, and all that kind of stuff. He works in an ER room where they see patients every day. People come in with bruises, lacerations, all kinds of things. And so, yes, he does fill out medical records that talk about certain bruises that he says he saw on Lindsay. But y'all see Lindsay the day of this incident. Y'all see her on the body cam. Or sorry, let me get back to that. Hello? Y'all see her right there. I'm sorry, but the bruising to the neck, I don't see it. The lacerations to the face, I don't see it. The contusions to the face, I don't see it. The contusions to the arms, I don't see it. And the reason why I bring that up is because remember when Killian Henson was in the car and everybody started to look at his spine and think that he was bruising? It is very easy to mistake things, look at things. You were told about bruises in this case that weren't there. You were told about a black eye. You were told about bruising down the spine. None of that was there. Anybody can write in a report that they saw bruising in areas. And I get it, he is a doctor. He's an emergency room doctor. He sees people every day. None of those injuries were documented. That doesn't make any sense. We've got pictures here.
He just said anybody can say they saw bruises. Oh, he's a doctor, but still, people accidentally see things all the time. Did he just say that? Is that what he just said? Okay.
So I'm asking you all to resolve that, to find exactly what happened. What I'm submitting to y'all is that with this photo of seeing Lindsay about 12 hours after the incident took place, plenty of time for any bruising to develop or anything like that, you just don't see it. The whole bloody mess about blood coming down her ears and all that stuff, you don't see any signs of that. You don't see the cuts that they're talking about. And Lindsay came up and told you the reason why that is because we got into it and we both grabbed objects next to us. His happened to be the stool and he went like this. And that makes sense because think about the size of the cut on her head. It's a 2 centimeter cut. If he had been standing over her, assaulting her with a chair and hitting her over the head with it, it's not going to be a 2-inch cut. It's going to be much more in length. There's going to be much bruise. There's going to be bruising, skull damage, all kinds of different things. Because the corner of the thing, the corner of the stool going up like that makes more sense with the 2 centimeter mark on her head. And she told you that. She told you the truth about what happened. The first time that she got the chance to tell anybody what happened that actual night, because this was an effort to get Mr. Henson out of the house, and then nobody talked to her. Nobody talked to her at all. Now, I want to get a little bit on specific charges as we go through this, because it is a little bit confusing, and I will be asking y'all to consider lesser included offenses. So let's go back to the indictment. Let's get jury charges on each of these counts. So, Ms. Jackson has certain elements that are her responsibility as the state of Georgia to prove beyond any reasonable doubt. And so let's start first with count 1 as to the alleged strangulation against Killian Henson. Ronald Henson is charged with using his hands and grabbing Killian Henson by the neck and squeezing, likely to result in strangulation. And so your determination is whether or not Mr. Henson did exactly that, held him by the neck and squeezed to a degree that was likely to result in strangulation. And so what Killian Henson told you is that he was suspended in the air and that he was put in the air and choked by his dad with one hand for 20 to 30 seconds. You then see pictures of Killian's neck, and he tells y'all, tell Lieutenant Collette at the time, Sergeant Collette now, that this did not hurt. And they all determined at the time that this was from a necklace. So again, when he says he was grabbed by the neck and he's got an imprint on the left side, he's 14 years old. Again, the words he used, grabbed by the neck. I know when I was a teenager, I was grabbed by the neck. I know when I was a teenager.
And Judge, I'm going to object to any personal experiences that Mr. Shapiro would like to share about anything personal.
Sustain, Mr. Shapiro, keep going.
Anyways, grabbing by the neck is not aggravated assault. Grabbing somebody by the neck and squeezing in a way that's likely to result in strangulation is aggravated assault. So
And Judge, I'm also going to object. That's an improper citing of the law. If the jury wants to find that someone was grabbed by the neck is likely to result in strangulation, that could be aggravated assault as well.
That's what I said.
Ladies and gentlemen, you'll receive a copy of the indictment. I'm going to charge you on the law. And you've heard the evidence, what the attorneys say in opening, closing, objections, questions are not evidence. I'll give you the law and you've heard the evidence. Go ahead, Mr. Shapiro.
So the indictment that the state chose to, I didn't draft the indictment, the state drafts this indictment, so I don't pick what the elements are, they pick what the elements are. And they indicted it as somebody grabbing Killian Henson by the neck and squeezing in a way that is likely to result in strangulation. So I don't know how to differentiate that from what was just said. That is the charge. That's exactly what they have to prove. And so they have to prove it's in that indictment. They chose to put by the neck and squeezing, grabbing Killian Henson by the neck and squeezing. They have to prove that. And that's not what happened. You heard from Killian Henson. And what he said on the stand was a little bit different than what he said at the time, which is that when he initially spoke to investigator or Deputy Truslow, his words were, he pushed me into the wall and that's it. Ms. Jackson played you that same clip, but just decided not to play the part where it said that's it. That is very important. He asked him what happened, and he said he pushed me by the wall, pushed me into the wall, and that's it. He didn't say push me in the wall and then Truslow interrupted him and he didn't get to finish his story. He said that's it. And then he goes and talks to Lieutenant Collette at the time with his mom, Andrea Gibbons. And the first time you hear the word strangle or anything even having to do with, he held my neck, and any related to strangling comes from Miss Gibbons. He does not say my dad choked me. He does not say my dad held me by the neck. He does not say my dad did this. He just shows that my dad held me by the neck in this way. I get it. Words for a 14-year-old are different, but held by the neck can mean two things, and it does not mean choking in this case. A few other things. Sergeant Collette never interviews Lindsay. And Sergeant Truslow, I agree he made mistakes, but he very much did a lot of the things that the state is trying to say he did not do. And I think that that's important, because it's not like he went out there. First, the story was that he was disciplined and that he only went out there once. Then when the state investigator Collette realized, oh, he did go out there a second time and do the report that everybody's been saying he didn't do for 2 years, he did do all those things. And so, yes, he was told that he needed to make a correction. He went out and made the correction. The whole argument that he didn't fill this out with Killian Henson's assistance doesn't make sense. He told y'all, yes, I didn't ask him each down the line that I interviewed him for 10 minutes and then filled this out according to what he said. And this actually does match what Killian told him. If you take this strangulation report, which is just titled a strangulation report, and match it up with that 10-minute interview, this is reflective of what is said in that 10-minute interview. Because Killian Henson was not strangled. Those are not appropriate warrants to take out then. They were not appropriate charges to bring to trial. And you know that because an officer with experience assessed the situation and did what he knew how to do. And if investigator Collette thought that there was an aggravated assault that didn't go charged, then she could have followed up, talked to Killian more, talked to Lindsay more, talked to McCarty. She did not do that. She did not pick up on the very concerns that she left off saying that Deputy Treslow didn't do. She doesn't do those things. Now, I'll be honest with y'all, I think one of the things that's happening here is that Deputy Treslow probably didn't do enough, and now Sergeant Collette is probably overcorrecting. I think that's one of the results of why we have this indictment is that Sergeant Treslow did not do enough, and Sergeant Collette is overcorrecting as a supervisor and trying to figure out how to help Killian Henson. By no means deserves this house. I get it. This is not an ideal place for a full keeper. I understand all of that. This is not to say that Killian Henson needed to be subjected to what was going on, but it is about the truth and making sure that Mr. Henson is barely
Pretzels and Dove dark chocolate with my mimosa is perfect. Seriously perfect, guys.
Anything convicted when he's responsible for what he actually did, not for trumped up charges that have to do with some dispute between two law enforcement officers that have totally different views on how this case should have been handled. The fact that two law enforcement officers have those different views is what I would call, what I think investigator Collette said, were missing links. Missing links is a red flag for them. Missing links is called reasonable doubt. Those missing links that she talked about that she failed to investigate are missing links that create the very reasonable doubt of these things and the very reasonable doubt that requires you to acquit Mr. Henson of any charge that the state has not proven beyond a reasonable doubt. I'll put that up there for y'all, but you guys are going to be instructed on reasonable doubt multiple times, and the duty that you have when the state cannot meet. No person shall be convicted of any crime unless and until each element of the crime as charged is proven beyond a reasonable doubt. And the reason why I focus there is I mean each element of the crime charged. And so the state, like I said, they draw an indictment, they put in the language, and then they have to prove everything in here beyond a reasonable doubt. And so when we go to things like aggravated assault, it does matter that the indictment says by grabbing Killian Henson by the neck and squeezing. Because if you didn't grab somebody by the neck and squeeze, then you didn't grab them by the neck in a way that's likely to result in strangulation. Every touching of the neck does not become aggravated assault just because touching somebody by the neck can somewhat result in strangulation depending on the manner. It does have to do with the manner of the grabbing, the manner of the hand placement. Just like when you get to offensive weapon and aggravated assault, the manner of the weapon and the manner of the object matters. The manner of how you do things matters because aggravated assault is serious. And so these are not to be under stress words the way that the state is arguing. These are important elements that the state must prove beyond a reasonable doubt. Now I want to get to count 3 having to do with the school. Now, I want to talk to you all about an offensive weapon. I believe Ms. Jackson told y'all that for an offensive weapon, y'all are to use your common sense and decide whether or not something is an offensive weapon. Now, the judge will instruct you on the law concerning offensive
Hi, Bill.
weapons. It's not just about common sense. And deciding whether a metal chair is an offensive weapon, you may consider all of the following factors.
Just so you guys know, I'm trying to find a case for me to start it. And then to see the verdict, you're going to have to go to Bell's channel. I don't have the case yet, but this is what I'm looking for.
Nature and extent of any injury inflicted, the character, the capabilities of the object or weapon, the manner in which it was used, any display of it to the jury, and any other circumstances of this case. And so I want to go through each one of those factors, show y'all why, even with that count as is, why it's not aggravated assault. The nature and extent of any injury actually inflicted. What y'all have here is a 2 centimeter cut to the head. And that's exactly what Lindsay told y'all. That is a 2 centimeter cut that she was able to wipe it off. This pool of blood that has been proffered y'all as something that happened did not happen. There is no pool of blood. Y'all have seen the place where it took place. You've seen that there was a carpet. You've seen that there was a hardwood floor and a bathroom. And that house was walked through. There's no blood to the extent of some kind of serious bloody bad. And keep in mind that an offensive weapon is something that is likely to cause death or serious bodily injury depending on the manner and the way it is used. And so when I get back to the manner in which it was used, I want y'all to think about this. If you are fighting with another person and y'all both pick up the objects next to you, and that's what you use to hit the other person, the manner in which it's used is not the same as a hardcore aggravated assault. It is not a bashing on top of somebody's head, taking a weapon and using it in such an offensive way that is likely to cause serious bodily injury. And I'm not trying to tell y'all that this is like self-defense or something, but it's in a defensive manner. When I say defensive manner, I don't mean that you have the right to do it. I just mean that it was in a defensive posture as opposed to an aggressive posture. Defensive as opposed to just bashing somebody and assaulting them. Any display of it to the jury, you haven't seen it. You haven't gotten a display of it. To be quite frank with you, the state's not even sure what the object is. I mean, the state indicted it as a metal chair. They're now backtracking on the whole wooden thing. The point is they're not even sure what the object is. They're not even sure what the object is, and they want you to convict Mr. Henson of count 3 beyond a reasonable doubt, and they're not even sure what the object is. But then again, like I said, even if you're satisfied on that count beyond a reasonable doubt, that's why I submit to y'all, you have the lesser included offense right here, count 3, of battery and simple battery. So you have the option of finding the defendant as count 3, you have the option of finding them not guilty, guilty of aggravated assault, guilty of battery, and guilty of simple battery. Now, here's my sincere argument on that. Because the state has not given you any display of the weapon, because of the uncertainty surrounding the medical documentation regarding these alleged injuries,
I'm pretty sure the documentation from the doctor was not uncertain.
you'd be fully
Hi, Tim.
authorized to find the defendant not guilty of aggravated assault. You'd be fully authorized to find him not guilty because of the way they charged it and the lack of proof for each element of that charge. However, if you are satisfied with that charge, despite the degrees of reasonable doubt that I've put up for there, you have the lesser included of simple battery and battery. The difference between simple battery is deciding whether or not there was a substantial visible harm versus simple battery just doesn't have that substantial visible harm. So it just has touching, if I hit somebody with this stick, there's no harm, there's no injuries, then that's when you get simple battery. On count 3, you guys saw Lindsay. You guys saw her. The injury is not visible. Now, it's obviously y'all's job to decide whether or not that 2 centimeter cut was substantial or not. And I'm not going to beat too much around the bush because if y'all find that a cut to the head is...
I know, guys. I know. Y'all is not professional. Y'all don't belong in no courtroom. Y'all. But this is Georgia, so it's a legit thing. So, no, it does not.
Substantial, but I'm going to go ahead and tell you guilty of battery family violence is okay. I'm not going to sit here and try to tell y'all that some cut to the head is not substantial. So I'm not going to tell y'all that if you find that this occurred, that this is simple battery, but you do have both of those options. What I am telling y'all is that it certainly is not aggravated assault, and you'd be fully authorized to find the defendant not guilty of that count.
I I'm working.
Now, I want to touch on the other part of it, is I'm not asking y'all to find him not guilty completely of every count. That's why I'm going through each one just differently and distinct, because I do recognize that Mr. Henson needs to be found accountable for what happened that night, just appropriately. And so the reason why I say you can go ahead and find the defendant not guilty of aggravated assault is because you have another option with regard to the altercation regarding Lindsay Shooter. And that's when you get to, that's when you get to count 4 and 5 of the battery counts in this case. And on counts 4 and 5, you've got 1 battery against Killian and 1 battery against Lindsay Shooter. And as to the battery regarding Lindsay Shooter, count 5, the state's allegation is that Mr. Henson slapped and punched the head of Lindsay Schubert and did intentionally cause substantial physical and visible bodily harm. Well, here's where the elements fall on this one. She never said that he was slapping and punching her in the head. She never said that she had bruising and all this visible bodily harm. You have not seen any visible bodily harm or bruising to her via photographs. You have seen what I've already played for you as Lindsay that day, and you don't see any substantial physical harm or visible bodily harm. And so as to count 5, where you don't have that substantial or physical bodily harm, where you don't have the elements of slapping and punching said person in the head, I would ask y'all to find him guilty of simple battery on count 5. Simple battery on count 5. So as we go through these counts, I've got a verdict form up here, and the judge is going to give this back to y'all, you deliberate, but you've got these options. And so I'm already going to tell you right here, as count 5, guilty of simple battery. That's what count 5 is. Now count 4 did intentionally cause substantial physical harm and visible bodily harm, bruising to the neck and back and killing Henson by grabbing by the throat and slamming said person against a wall repeatedly. At that point, what you've got is the image stage 4 to Killian's back. And I'll go ahead and let y'all know that that injury on the back, his back, is consistent with being put into the wall, grabbing by the throat, slamming, whatever that verbiage is, being put into the wall. Now, obviously, Matilda, the state has, in fact, indicted very specific language of grabbing by the throat and slamming said person against a wall repeatedly. Now, like Ms. Jackson told you, she's able to prove those through alternative methods as long as you find one or the other. But still, he says that he was grabbed multiple times, thrown back in, and that goes towards witness credibility. That goes towards the credibility of Killian Henson and whether or not a lot of his story makes sense. A lot of what he said was 20 to 30 seconds on the wall, then he was in a laundry basket. Some of it just didn't make sense. And to me, what it all sounded like was Mr. Henson did what I told y'all he did, which was put him against the wall. Now, if y'all find that that's substantial and or visible, then you'd be authorized to find him.
I think you and Shapiro would make a great team. Miles, hours. I'm going to stay on as long as you pay me or not. Don't pay me. I'll go to bed.
My position on that count to y'all is that the state has indicted count 4 as quite an aggressive battery, quite an aggressive way of grabbing by the throat and slamming said person repeatedly. And personally, I think it was, like I said, one time to the wall, put him into the wall. And obviously, tell them that's a simple battery, not a battery. But like I said, really the point of that language of grabbing by the throat and slamming said person repeatedly, it's not that repeated element, but it's just more so that it cuts against the credibility of what was claimed by saying that that's what happened. And now we know that all the time he said once. So this just does not track. It does not track based off of his testimony until his mom got involved. That's when things changed. Now, I want to talk a little bit about Andrea Gibbons and why she matters to reasonable doubt.
But that's a 24-hour stream. Ain't nobody want that. Come on. No. JK, you shut up. He can't do math. He asked how much it was, which means he doesn't want to do the math, which means I add that $2 math fee on. Hold on, I gotta delete. I gotta delete JK's comment before anybody reads it. It's a $2 math fee. No, wait. There's no free. Oh, the first 2 hours I always do for free. I'll stay on as long as you guys want me to. You just got to pay me $1 per minute. And I will do a stream up to 24 hours. Because I'm a human being, not a freaking robot. But that's next Monday. Then no, I'm sure I have it. I'll find it. Give me a second. I'll find it.
So, Andrea Gibbons is not named victim in this case. She is the mother of Killian Henson and is formally involved with Ronald Henson. But a lot of her involvement hits on the doubt that comes with this case. She came up and told y'all, nobody came out and looked at my kid a second time. She said she got that from someone. It seems like she probably got that from investigator Collette. Now, I don't think Sergeant Collette lied to her. I think Sergeant Collette probably told her view, which was, I don't really think anybody else has been handling this correctly. And Ms. Gibbons probably ran with that as, well, nobody's even been out here to see my son. So I'm not saying Sergeant Collette told her to lie or anything like that. I'm just saying that Andrea Gibbons ran with a lot of maybe overhyped ideas that were more personal between Collette and Truslow, and Ms. Gibbons ran with that. But like I said from the beginning, the first thing she asked about is throwing Mr. Henson in jail. She, in fact, goes to the hospital, and the second that they find out, I think y'all saw it in the narrative, once they thought that Mr. Henson was in custody, she no longer wanted to talk to anyone. She no longer pursued anything else, because this wasn't about all of that. This was about her getting back at the father of her child. Now, when we get to the strangulation counts, like I said, I think for Killian Henson it's pretty simple, which is you've got the documentation that shows he likely was not strangled. The state needs to prove that beyond a reasonable doubt that he was grabbed by the neck and squeezed in a way that was likely to cause strangulation, and they have not proven that. I believe that the evidence has disproved that almost to a T. Now, we don't have to disprove anything. We just need to show you all that the state has not proven it beyond a reasonable doubt. But the evidence from Lindsay was that he was in the room for about a few seconds, came back out. There was no 20 to 30 second encounter. From Killian, it's almost consistent until he gets to Ms. Gibbons that that's it. Push once against the wall, and that's it. Just like I put up there. So when you go through the counts, kind of gets a little confusing, but the way that I see this working out to get to the truth in the middle ground of what maybe Mr. Truslow didn't do enough on, and then the rest of law enforcement kind of ran with and overdid, which is this. As to aggravated assault strangulation regarding Killian Henson, I'm going to ask y'all to find the defendant not guilty. He did not strangle Killian Henson. There's not proof beyond a reasonable doubt that he did that. And so I'm going to ask y'all to find him not guilty of aggravated assault strangulation of Killian Henson. Now, for each one of these, you do have a lesser included of simple battery. And what that really means is that the law says that we have aggravated assault. We also have batteries. We also have simple batteries. And so all that is the judge is going to instruct you on these different offenses and let you know that if the state has proved some of it, but not all of it, and enough to satisfy you as to these, then you could do a lesser included, but they still have to prove that lesser included beyond a reasonable doubt. So you would still have to look at those elements and find some guilt beyond a reasonable doubt as to at least one of those lessers. But as to count one, I firmly submit to y'all that count one is not guilty of aggravated assault. Count 2, concerning strangulation of Lindsay Schubert, not guilty. She took the stand and she told y'all the reason why she told people at the beginning that she was choked was to get him out. Y'all saw her neck. The bruising that the doctor, I think it was Dr. Negroni, testified about is not there. And I get it. I'm not saying that he lied. I'm not saying he's not credible. It's nothing like that. But he's referring to documents from 2 years ago, doesn't have a picture. I mean, you saw how he talked, you saw Dr. Killian's records, and he talked about how, look, I just see that a patient and a parent was in here, I wrote this, but he can't tell you any more than, look, I wrote what they said, and that's about what I wrote. But asking them to then tell you, I remember this bruise from 2 years ago, he could not remember a whole lot about it. And so as to aggravated assault concerning the strangulation alleged against Lindsay Schubert, I would ask y'all to hold the states of their burden and find the defendant not guilty of that count, but then you could consider their simple battery. There's no physical injury or visible marks to her neck. And so whereas the other aggravated assault with the parent might be a battery, this aggravated assault, if not aggravated assault, and if not guilty, would be simple battery, not battery. But I submit to y'all that he is not guilty of counts 1 and 2, aggravated assault. Count 3, aggravated assault. That's really where it gets a little tough, because obviously something did happen there to the head of Lindsay Schubert. Something did happen with that chair. But I submit to y'all that he's certainly not guilty of aggravated assault on this count, based off of the fact that you have no images of the photos, based off of the fact that Lindsay's testimony itself has been inconsistent across both ways, based on the fact of the manner of which that tool was used. I'm going to ask y'all to find the defendant not guilty of aggravated assault, or in the alternative, guilty of a lesser included offense. I stress to y'all that the manner of the weapon is important. Generally, aggravated assault has 2 categories: deadly or offensive weapons. When it's a deadly weapon, we say it's deadly per se, guns or knives. When we go to the offensive weapon, that's when you consider the factors. But that's all very important, because that's what we're talking about with aggravated assault. Very serious stuff, not the manner in which this was used. So like I said, as to count 3, I would submit to y'all with the lack of evidence y'all have and the lack of anybody following up with Lindsay, including investigator Sergeant Collette, to find the defendant not guilty, but in the alternative, to find him guilty of a lesser included offense on count 3. Now, the judge is going to tell you to check one of these. I'm not telling y'all to check 2. This is just me filling it out the way that I think is appropriate. These would be the 2 lessons. But you do have to pick one option. Now, as to count 4, this is with regard to sorry about that. As to count 4, and this is count 4, is the battery on Killian Henson. And again, like I said earlier, it's up to y'all to decide whether this is substantial and or visible. It's obviously visible, but the main thing that I ask y'all to look at here is, was it done in the manner that they said he did it in? And does that cut against any credibility as to the aggression that's charged in count 4? And that's where I would ask y'all I might ask y'all to hold him accountable for putting his hands on Killian. That's for y'all to decide whether that's guilty of battery or simple battery. I can't tell y'all to find him not guilty of count 4. We know that he pushed Killian Henson against the wall beyond a reasonable doubt. That's clear by everyone. And so the question for y'all on count 4 is whether he's guilty of battery or simple battery, in my respectful opinion. Now, I think, like I said, because of the manner in which it was alleged and the material distinction from what actually happened, that it's not battery, that instead it's simple. And so what I'm going to ask y'all to do regarding count 4 is to find the defendant guilty of simple battery. And so what I'm asking y'all to do, in sum, is to take these charges appropriately and look at the elements, and don't just come back with aggravated assault because something did. Take care of each charge independently. And I think what you will find as you do that is that the defendant is not guilty of strangling or squeezing or grabbing the neck of either person to a degree that is likely to result in strangulation. He's not guilty of counts 1 or 2.
Thank you.
As to aggravated assault, count 3, again, like I told you, not guilty for the reasons I said, but even if you find something, guilty of battery or simple battery, I'll be honest with you, I think either one of those would be warranted, but not guilty because they can't even allege the right weapon. I mean, it's the metal stool. They don't even have that right. There's no display. There's no photos. And so that's why I think you're fully authorized to find him not guilty of count 3. Because you could say, well, something happened, but if you're just not sure what happened in count 3, and you can't be satisfied beyond a reasonable doubt as to what happened in count 3, then your duty is to acquit the defendant. Then your duty is to acquit the defendant, and the judge will instruct you on that duty, that standard, what you all promised to in opening statements, or sorry, the board hour on Monday. Now I'm going to sit down in just a minute, and when I sit down, Ms. Jackson will have an opportunity to make her second and her closing arguments, and she can be able to address anything I said. In turn, I do not get to get back up. I will not get to give y'all another explanation of Mr. Hanson's side of my side. And so all I ask y'all to do, this is part of your role as a jury deliberator, is to take those sides, to listen to what Ms. Jackson has to say, but also to think about the things that I put up and the counter argument, because it is her burden, not my burden. It is the state of Georgia's burden. And so I want y'all to consider these points of doubt. Consider any doubts that you know throughout the trial. And I think, I'm confident that through honest deliberation, through looking at the charges as they appear, you will be able to return a verdict that speaks the truth and holds him accountable for the counts he did, and gives you the middle ground appropriate result between Sergeant Collette and Sergeant Treslow. Where Sergeant Treslow messed up is that he took out a warrant only concerning Killian. He did not take out a warrant concerning Lindsay. And I recognize that he should have taken out a warrant regarding both, not against them, but against Mr. Henson regarding both of those named victims. And so that's why I'm going to ask y'all to come in and reach that appropriate result. Reach that appropriate result. And the last thing I want y'all to know, one thing that I want y'all to consider, is that the judge is going to instruct y'all on the rule of a single witness. And what that means is a single witness is sufficient to establish a fact. So for both me and the state, any witness that testifies, they can establish a fact. And so that goes for both our witnesses and their witnesses. And through that testimony, these facts that have been established, that Deputy Treslow did a lot of the things that they said he didn't do. His testimony speaks more volume, because while he might have messed up, a lot of the things that he did regarding Killian, he treated him with respect. He talked to him. He took pictures. And so I get it. He wasn't perfect, but with regards to Killian, with regards to respecting Lindsay and doing what they wish.
Either or.
He handled the situation appropriately in the best way that he needs to act. And so I ask y'all not to fault him. He has years of experience. He has seen real danger. He has been overseas. He's been on the streets. He gets it. And so he appropriately assessed the situation and handled it. And I ask y'all to give him the credibility that comes from his experience. Like I said, he grabbed me by the neck, pushed me into the wall, and that's it. That is it. It's a high standard. It's a very scary standard, but it's important for our system. And I appreciate y'all bearing with us through these 3 long days.
Shapiro is a public defender. We've seen him a couple times, and we get so frustrated with him. He usually fights with this judge over and over again and keeps asking the judge to recuse himself and asking for a mistrial.
It's a lot of this to do your job, to do your role. And I'm confident that in doing your job, fulfilling your role, you will find.
Listen, I don't know. Including him, everybody says he did it. Including him, he said he did it. So I don't even know what a good lawyer would do for him.
Guilty of aggravated assault, but guilty, two lesser included, civil battery, or, like I said, on the counts for battery, seems like a reasonable outcome, more than authorizing that. But like I said, consider each count, look at the evidence. It's not about did something happen or what we think happened. It's about the state proving every single one of these counts beyond a reasonable doubt if they can. Your job is to acquit the defendant. So I'll ask y'all to do just that. In just a few minutes, Ms. Jackson will get up. The judges can give you instruction on the law, and y'all will deliberate. I just want to say I appreciate it. Just take it seriously. It's your duty. Thank you.
Ms. Jackson.
Thank you. People are going to keep saying that the whole screen right now. Absolutely. Absolutely. Buster, Chinny's gonna give you a towel. Chinny, Buster needs a towel.
Ladies and gentlemen, from the beginning, defense has been telling you, yes, something happened. Yes, it was physical. And what the state did throughout this trial was bring you the evidence to show you what happened, that being video evidence, medical record evidence, phone or picture evidence of the injuries, and testimonial evidence that came from the witness stand during this trial. All of those things to show you what that something was that happened between 14-year-old Killian Henson and his dad, Lindsay Schubert and Ronald Henson. And at this point in time, the defense is here and to try to cast this doubt and make up these stories for you about broomsticks and various things like that at the last minute, again, to see what you all will bite on as jurors when evidence was actually given to you from that period of time 2 years ago. They want to say, oh, there's been disputes and all of those things, but ladies and gentlemen, you have Killian, an independent witness, you have these medical records. There hasn't been a dispute about what happened from the beginning. Deputy Truslow did not his job, but Killian had been saying from the beginning, I was grabbed by the neck. And then when he gets saved, as he called it, more thorough, talking to from Lisa Glenn, he actually gets to explain to her what that was, how it was. He's always maintained he was grabbed by the neck. And Lindsay Schubert had always
Thank you, Fossey, for purchasing the first 100 minutes.
maintained. At the time, her very first statement to law enforcement, you tried to choke me out at the hospital. You tried to choke me out. He hit me over the head with his stool. All of that has remained the same. Now, Truslow chose to go there, just asked his minute to leave, and the two that those things weren't there. You heard his first question to Lindsay after she described 2 aggravated assaults. This is your house? He doesn't even follow up on that at all, not ever, not once. Then, for some reason, he's contacted by this defendant. That's pretty interesting. And then, this defendant attempts to get his 14-year-old to change his testimony and pretend like something didn't happen. And then what does Lindsay do? She goes ahead and changes her testimony on the stand before you all. Look at that. Does that make sense? Why did that happen? You consider it. And I suspect that you would want. What doesn't have any motive in this case, ladies and gentlemen, is these medical records. Because when you look through these medical records, you're going to see exactly what they told the doctors, exactly what was shown in these records, what the doctors saw. I understand Mr. Shapiro wants to tell you that from his view of the body cam, he can't see bruises and all that stuff. Ladies and gentlemen, these are emergency room doctors that have documented actual contusions and bruisings about what happened in that case. And these records are these records. They do not lie about what happened. Killian has been consistent and has not lied about what happened. From the beginning, he told you what happened to both him and Lindsay. Do you think that he wanted to be here when 13 strangers to testify about this horrific, brutal attack?
Nobody wants to be here right now, woman. Shapiro sucked the enjoyment right out of us. So if you're new and you just joined, next Monday, I'm going to do my normal 2-hour stream. And then I'm done. I'm good. I did my job. If you want a longer stream, up to 24 hours, it's $1 per minute. Zach, that counts as 5 minutes. It does. YouTube takes what YouTube takes. It's fine. So it's up to 24 hours. I'm really not I'm looking forward to that, but I'm just saying I'm going to keep going as long as you guys want me to. And if you want me to, it's $1 per minute. Fozzie already got the first 100 minutes. Sorry. Zach got 5 more minutes out of me. I do not have to be on screen the whole time. Oh no. Oh no. There's no space in between the last I and the V in that text. It should be Abby, I, and then a space, then no. But no, Zach, it's too late. No take backs. But see, Abby is my gamer name. Any game that I play in, I'm Abby. So I set my Venmo up as, my Venmo up as Abby a long time ago. Oh, Fletcher, you didn't say this was for Monday, so it doesn't count. Wait, guys. Hey, wait. Does that say it's for Monday? No, it doesn't, does it? Oh, I'm going to have alcohol, Monica. Okay. So that's what's going on Monday. I don't know how long I'm going to be streaming. There's probably going to be no OJ because Fozzie just took OJ's time away. Fletcher, thank you so much. Springsteen, thank you. 2 more minutes. I hope someone's writing this down. 107 minutes so far. I'll put something in Discord as so we can keep track of how many minutes. And just so you know, every single after the 2 hours, I'm gonna pause whenever I want to talk. It's gonna be a fun stream.
That's why it is his own dad. I submit to you not. But again, as I told you in the beginning, he's trying to pick up those pieces and trying to do the right thing, even after his very own father tried to influence his testimony. Think about that when you are deliberating, ladies and gentlemen. It is extremely important. All this discussion that Lindsay has about this broomstick and all of this type of thing, think about that as well. What makes sense? She never said that before. She never, her spontaneous statement was what happened. Her first statement to law enforcement. He tried to choke me out. He hit me over the head. Never have we heard of that before this trial. And again, ladies and gentlemen, mighty convenient to go ahead and introduce that while she's simultaneously changing her testimony in the trial. Awfully convenient. So is that what happened? Or is what happened what I showed you happened in the evidence? And what I proved to you beyond a reasonable doubt. Now we talk about Deputy Trestle a little bit. Yes, there's a lot of stuff that he did wrong. And like I said, he's not a bad person. He's done plenty good for our country, but unfortunately, he did get some things wrong about this case. He admitted to you that he didn't go back and and go to the hospital and talk to these folks. I heard a kid, I heard a woman. He admitted to you he didn't do any of those things. He never once walked through and tried to find the broken phone. He never asked Killian what happened to start out. He took 20 or 30 seconds with him at the house when he was instructed to be by Lisa, but never asked him more questions like the strangulation report or anything like that. He didn't do any of those things. None of those things to Lindsay either. And I was trying to figure out what the goal of his testimony was. Like, I don't know if it was for him to come up here and say, well, it's really not that bad, like convict him on the lesser included offenses. But then I got to thinking about it and I was like, but what about all this other stuff? Like, how does that all add into it? So I think he just missed, unfortunately, on this case because the evidence shows that Mr. Henson is guilty of those counts of aggravated assault, those counts of battery as he's charged with. Lisa Collette, at the end of the day, she's trying to figure out what's going on and try to gather all this stuff and figure out why she's being told all these things and there's injuries to a child, but yet Troso pretended like nothing happened. And so she's trying to figure out all of that. And it's not that she never follows up. She told him to do it as a supervisor, him not usually on her shift. Told him to do it, expected that he would follow orders as a law enforcement officer and former military, and he didn't. He never did. She thought he did. She testified to you that. And she also testified to you that she followed up with the solicitor's office to make sure that the appropriate charges were going to be brought. So she wasn't just letting this dilly-dally out there. She was going to make sure that that was in the works at some point in time when she realized that he did not, in fact, follow the orders. But, ladies and gentlemen, at the end of the day, if you don't like Lisa Collette and you don't like Deputy Trusso or either one or vice versa, just go back to the basics. I would urge you to just go back to the basics in this case, which is the two victims in this case, Killian and Lindsay. And what they said, because Killian has said from the beginning that he was held by the neck. He didn't use that word strangle. We talked about that. He's 14. I don't expect him to use legal terminology. He said he was held by the neck. Likely to cause strangulation.
Monica just got an hour. Thank you, Monica. Thank you. Thank you.
Remember how we talked about that in my first closing? What is likely to cause strangulation? Don't have to prove actual injury. He's guilty of aggravated assault, strangulation against Killian. Back to the basics with what's in the medical records. Back to the basics with what Lindsay testified to, or not what Lindsay testified to, but what she initially said to the officer, and then also what she testified to because she told you she was struck over the head. She tells the officer, first thing out of her mouth, Kevin, yeah, he snapped and he tried to choke me out and he hit me over the head with this stool. Back to the basics with that, ladies and gentlemen. What does it show? It shows what the state has charged in this indictment. Now, Mr. Shapiro, I copied his list that he had put up for you all, and I want to discuss those. So he put up these points, and I want to talk about them, ladies and gentlemen. So he said you have no photos of Lindsay. Well, you heard from a medical professional, a trained medical professional, ER doctor, that they don't always get pictures. There was a different doctor for Killian. He happened to take pictures. Guess what we have? We have documentation in the medical records about an actual laceration and tons of contusions on the front of her neck. He said that indicated real trauma to the front of the neck, i.e. count 2, i.e. strangulation to Lindsay. So that doesn't always happen, and that is why. Now, we don't have other medical photos. I don't know if he's saying photos from Lindsay before. Well, that's because Trusso never went out, but we don't have photos of her at the hospital. That's because what I just told you, it's in the medical records, and the doctor testified that not every single time do they get pictures, but he does document it, and it's all right there. Contusion.
It's not easy, you know. This is not easy. It takes all of my hours, every single hour of my day for this. So no, it counts half praise.
lacerations. He's there. He talked to you about it. He's a trained medical professional. Why is Killian unreliable? Why did he even put that to you? I don't know. It's a 14-year-old child, again, like I said, trying to pick up the pieces, tell an authority figure what happened from the beginning. Even after his own dad tried to influence his testimony, Killian's not unreliable. Killian is the most reliable person in this case, ladies and gentlemen. He pushed me into a wall and that's it. You know what, ladies and gentlemen? Again, he pushed me into a wall. That was his first statement to Truslow after Truslow didn't talk to him. And he's talking about being held by his neck. And he says Lisa's more thorough.
Idaho, I just bought 4 large coffees, then changed my mind. And you can have all of my coffee.
You would held by the neck.
It's a 14-year-old telling you he's hurt, and this is how he describes it. Now, Andrea's unreliable. Why is Andrea unreliable? Andrea doesn't, she's trying to protect her child, but her child has said the same thing this whole entire time. Does she have an emotional reaction when she turns around and sees the injuries on her child? Yeah, sure. I don't think that means that she's unreliable. Sergeant Collette didn't interview Lindsay. Well, Sergeant Collette told Deputy Truslow to go back and do it. You heard him admit on the stand. He didn't. Even after he had the phone call with her where she's like, yeah, I'm not feeling good. I'm at the urgent care. I'll be right over. Never goes. Sergeant Collette followed up with the solicitor's office to make sure that those appropriate charges got brought. Truslow did a majority of the things. I don't know what a majority of the things are just through the questions that I asked him about on the stand. I'm not going to go through that with you. I know that you all remember all of that. No follow-up by Collette despite her concerns. She asked the solicitor's office, hey, I realize he didn't follow my orders. Are y'all going to take appropriate charges? Yes. And now we're here. There's no reasonable doubt in this case, ladies and gentlemen.
What makes sense? I've talked to you about that. You guys use your life experiences and your common sense and listen to everything that we've presented. Consider what makes sense and why things have played out the way that they have and why things have not played out a certain way. Just think about all of that. Why was the broomstick involved and talked about last minute? Yeah, sure, it was in the body cam, but so was, I don't know, probably a can of, corn or something in the pantry. Just a lot of stuff in the body cam. That doesn't mean anything. Like, yeah, there's a broomstick there, everything else was there. Point is, she never mentioned it until this trial, 2 years later, after he's been trying to influence folks' testimony. So, what's not new? Broomstick's new. What's not new is what's been being said this entire time by the child. And so, we got all this talk about a broomstick, but check this out. Here's Mr. Henson at the time. Deputy said he didn't see any injuries on him because he didn't have any injuries on him. So what makes sense? What Lindsay said at the beginning, that this was a bloody, brutal attack. He doesn't have any injuries on him. She wasn't coming after him with a broomstick. What's not new is what Killian's been saying.
That doesn't hurt at all. Like, that doesn't, I can't.
What is that from? Strangling him?
Yeah, when he helped me against the wall, he helped me by my neck.
Did you tell the other officer that?
Yeah, I told the other officer that.
And he's telling Collette there. He's not trying to hide the ball. He's trying to say, as a 14-year-old, I've been held by the neck, which relates to the legal terminology of likely to result in strangulation, which we talked about, ladies and gentlemen. None of that is new information. There's been a lot of things in this trial, ladies and gentlemen, that it kind of creates this scenario that you've got all these things going on, right? You've got this defendant trying to contact his kid and say, pretend like you don't know anything when you go in the courtroom in front of the jury. You got Lindsay actually doing that and totally recanting. And you got this defendant contacting the officer before he came to testify.
No, but I'll do
That's
mine.
all very,
Oh,
very
thank you.
concerning,
Okay.
and should concern you as jury as well. That it's just more of Ronald Hinson's manipulation tactics. I told you in the beginning of opening, if you get in his way, things don't go the way he's gonna do, he's gonna find a way to make it work and try to make it work, and that's what he's done here by trying to influence folks' testimony. You got that happening with the recanting of use fix on Lindsay, even though she said what happened at the time. You got this officer who didn't quite follow through with his job and do everything that he was supposed to do. But ladies and gentlemen, please do not let that distract you from what the right result is in this case. I urge you to please consider each count as it's charged, and there's a reason for that. Don't let Truslow's mishandling or Lindsay recanting after folks have been trying to be influenced keep you from what actually happened and what the state proved to you in this case. Please do that for what it is. And consider what evidence there is to back that up, and you'll have that back in the jury room. Most of this will go back to the jury room. If you want to watch videos or something that doesn't go back, just let us know. We can accommodate that. You can let the court know that. But my point is that this is not some attempt to get wrong. It's not some way to just trump up the charges on him or something like that. These charges are brought because we have given you the evidence to show that he's guilty of these charges. It's not these lesser charges that they want you to buy on and go ahead and compromise on. He is guilty of these charges, and that's what this evidence shows. It's not an attempt to try to get him or anything else. It's not a trust limit and do enough so Lisa overcorrected. No, these are the appropriate charges. Don't let that other stuff influence you from what actually happened, what the evidence shows. Please. Now, we get to this point in time, we've got, as I said, the defense making up all this stuff to see what you guys will lie on, and he'll take the bait and believe it about the broomstick stuff, about none of this ever happening over the past 2 years. Lindsay getting up on the stand for the first time and saying that she had lied about being choked or strangled for some reason, even after folks had been trying to be influenced to testify. And they had to come up with something to see if y'all will go ahead and take that, even though the evidence shows otherwise. But there's a reason that you all were chosen to sit on the jury. There's a reason that Colette got involved in this case. There's a reason that all of these things happen. And so I would really ask you to not let this side story of Trustlow and all of this stuff really get in the way of seeing what the evidence shows. What the state has proven to you in this case. There's no missing links like the defense wants to tell you. It's all been there from the beginning. It's just unfortunate that Trustlow didn't see that or didn't bother to follow up and do that job. I think the defense in this case is trying to get you to almost fight on that and almost take that bait and almost have it by getting some lesser included or doing something like that. But you have the power as this jury to tell them, no, you don't. That's not how we're going to go. We're going to hold you responsible for what you actually did. That you cannot skate by assaulting a child, assaulting a woman, attempting to influence them, getting one that came up here and told a different story. You have the power to say, no, we're not going that way. This is what you're responsible for, which are these charges brought. I'm asking you to find him guilty on those charges. Killian was clear from the beginning. He held by the neck, pushed against that wall. He's got the bruising, he's got the markings on the neck. Again, at 14 years old, he's trying to reach out and tell people who are supposed to be in authority, law enforcement, what happened. And so when you're considering what makes sense later, you don't even think about that. Think about what goes with the evidence, the medical records, the photos, all the testimony that Killian has talked about from the beginning and what might have changed over the course of this last 2 years, or suddenly a broomstick is talked about and things of that nature. You had the chance at this jury to rectify the situation and tell Killian that we heard you for the first time at these videos up here, we hear you now on the stand, we believe you, and we know you're trying to pick up the pieces and do the right thing, even after your dad himself tried to influence your testimony. You won't have the power to do that and bring justice here for this case.
No. He
that
does
is
not.
not.
He's not.
When I asked you and started talking to you about the lesser included here, it's so.
She used 32 minutes of her 1 hour in closing. And then he used whatever time he used, 7 hours. I don't know. We watched it right here today. And now she has her remaining minutes that she's using, and she's almost done.
Important because that is not what this case is. It's not a let's compromise and just go on the lessers. I'm urging you to consider what actually happened and what the evidence shows. Regardless of Deputy Trusto not doing his job and admitting to you that he didn't do that job, what Killian has been saying from the beginning. And that's why I'm asking you to find him guilty of aggravated assault under the Family Violence Act for strangling Killian by putting that hand around his neck, which is likely to result in strangulation. He talked to you about how his voice changed and how that felt for him.
You would have paid attention more had she been anywhere near a microphone. But she kept wandering around and you couldn't really hear her, and we were chatting in chat.
And he had been saying that from the beginning, that he was held by his neck and pushed against that wall. Now, in count 2 was Lindsay. I'm asking you to find guilty of aggravated assault for strangling her because her first statement to start off this case was he tried to choke me out. Because that's what happened. And then she told the hospital that's what happened. He's guilty of count 2 aggravated assault under the Family Violence Act, ladies and gentlemen. This is not a lesser included type situation, which the defense wants you to believe and wants you to compromise and bite on. Count 3, of course, we talked about that. The elements it takes to prove aggravated assault. If you find that she was assaulted with an object that you consider offensive, you can find guilty of count 3. And so I'm asking you to do that because, again, that's never wavered. She said in the beginning that she was hit over the head with the stool. She said at the hospital she was hit over the head with the stool. She said here she was hit over the head with the stool. Guilty of count 3. Count 4, that's talking about the battery to Killian.
Mic drop.
And on that one, ladies and gentlemen, what I wanted to point out to you is that indoor language that we talked about. If you find that the state proved that in either way, you are authorized to find him guilty of that. So there's that talk about repeatedly. If he did it once, that's enough to convict him of that battery. Be it either way, he caused those markings on Killian. You can find him guilty of the battery. It's not a simple battery situation. It's not a compromised situation. There's that visible bodily harm. It's not a simple battery. You have the photographs and all of that to look at for that visible bodily harm on count 4. And then on count 5, talking about the battery on Lindsay Schubert, by striking her, causing those bruises, and again,
Slapping or punching. So slapping and punching in the indictment, the and/or charge that I told you with the receipt and the judge will instruct you if you find either way, that's enough to prove that battery. Again, visible injury. So in the medical records, there's continued vision. We hear that from the doctor, we know that this bruise and lengthened speed. And we know she also has some lacerations to her head, so there's certainly that visible element there for battery, not just a simple battery, not just an offensive touching, visible injury to a person.
and so on counts 4 and 5, that's why I'm asking you to find him guilty of battery under the Family Violence Act and guilty of battery under the Family Violence Act. This is not one of the lesser included. That does not fit here, ladies and gentlemen. And so what the evidence has shown from the beginning, I've talked about that. I submit to you that that is what happened, regardless of Deputy Truslow. You have seen it through each course of this trial, that this is not new information. This has all been there since the beginning. Killian has been saying the same thing since the beginning. He's talked to authority figures, he's talked to you about what happened. Lindsay said the same stuff from the beginning.
A while. This was not a quick one.
Only now she's decided she wants to say she wasn't actually strangled. We know what happened, even after the defendant tried to influence his child's testimony. And last,
3 minutes left, Ms. Jackson.
I'm sorry?
3 minutes.
Yes, Judge. And lastly, ladies and gentlemen, all of this evidence in total, and I put just a good bit of it up on the screen, but you'll of course be able to look at it. It matches up to the things that are present in the indictment. All of that goes with what's in the indictment. It's not some lesser compromise type situation of asking you to please and urging you to hold this person accountable for these charges that he was charged with. Not some lesser something that does not apply. Please remember, and it speaks the truth in this case, one that actually holds him accountable for abusing his own 14-year-old son is the person that he was living with at the time. I'm asking you to find him guilty of all the counts as he's charged, as this evidence shows you, ladies and gentlemen. Thank you.
Ladies and gentlemen, we're going to take a 5-minute restroom break. Please remember your admonitions, and we're going to start back in 5 minutes or whenever everybody's done going to the restroom. All right?
So I'm fairly sure I did not cut out this 5-minute break because these two talk to each other the whole time and you can kind of hear it. But now that I think about it, it's really not interesting. So I'm just going to fast forward it to the interesting part that we want to know. Oh, we got to look right at the camera there. Watch. Here you go. Just sit down right here. Now what does it even look like?
Remain seated, come to order.
All right, as to the evidence that's going to go back, what evidence do y'all have that's going to go back to the jury?
Judge, we have all of the photographic evidence, so starting this in order, we have states 1, 2, 4, 5, and 8. Those are all photographs, and Mr. Pierre and I both looked through those. The things, and we're all in agreement about the body cams and all the flash drives staying out here, which is states 6 and 9, and then defendants 1, 2, and 3. The only thing that we have a point of contention on, Judge, is states 3 and 7, which are the medical records, and then defense is 4, which is the strangulation report. I think we have it. I don't know.
And I think where we're at on that, Judge, is that the medical records have a lot of narrative portions. So my thought is that because of the narrative portions, we would otherwise have to redact portions of the medical records. So I think it'd be better to just treat that all as a continuing witness document and keep it out here. And then I think maybe Ms. Jackson might have the same view on my defense 4, or maybe she has a different position. But I think that one would go back just because there's not really a narrative. It's just a filling out of the form.
So as it relates to the medical records, I agree. I don't want to, neither one of us want to get in a situation where we're trying to redact out narratives or something, but I do want to ask the court if maybe that you can just like the videos if you want to see it, like we're keeping the medical records out. You can see it if you want to, you just have to ask. But as it relates to the strangulation report, my view is the same as the medical records. I think both should be treated the same, whichever way that is treated, just because there is
narrative portions of the answers, which the deputy testified that he got from speaking with the defendant. And so it's not just, I can hand it up if the court wants to see it, but like he's got numbers on there describing how much, strength was used and different things like that. So I do think that some of these answers are testimonial in nature and would be a violation of the continuing witness rule.
All right, let me think about that. I'm gonna go ahead and charge the jury. All right, stay ready.
Yes, sir.
Defense ready?
Yes, Your Honor.
Let's bring the jury in.
Okay, yeah, you come on.
Oh, guys, I'm in trouble. Guys, I'm in big trouble. Guys, I didn't expect this to happen. Nan just bought 50 minutes. Now I have to find the best 50 minutes of content on the internet this week. Like, it has to be the best 50 minutes. Now I need to know when I'm going to do Nan's 50 minutes. Should I do Nan's at the beginning, middle, end? Thank you, Nan. Whoo. This is too much pressure. 58 seconds left in this video, guys, but don't worry. The judge says something here. Here we go.
All right, everyone, please be seated. Ladies and gentlemen, we're about to enter the next phase of the trial, which is the charge from the court. This is a very important part of any jury trial because this is where I'm going to give you the law. I have to warn you, though, it's probably the most boring part of any trial because I'm going to read to you the law. But please give me your attention. Ladies and gentlemen, you're considering the case of State of Georgia versus Ronald Kevin Hinson. The grand jury has...
Of course, I'm not going to make you listen to the jury instructions. Did you think I was going to make you sit there and listen to all the jury instructions? Hell no, we don't do that here. No. Okay, they're off, guys. They're off to verdict. We will find out tomorrow what happens. And the verdict is quick and easy portion of tomorrow. But then something happens after the verdict, but I can't tell you what it is because that'll tell you what the verdict is. That's a little longer. Oh, Fozzie, you don't even know what you just said. You have no idea what you just said. But I'm going to answer you, Fozzie. I'm going to answer you. You don't know what you just said, but I'm going to answer you. Yes, I am. Not 400. Try 1,500. Don't worry about it. It'll be fine. Just relax. I got something so huge that I'm working on for you guys. It's huge. It's humongous. And it's going to take me, oh man, it's going to take me till the end of my whole goal is to get it done by the end of the OJ trial. It's big and it's going to be great. And I found some tools that it's just awesome. Wait till you see it. Wait till you see it. No, Fozzie, I promise you need to trust me. It's going to involve voice changers and cartoons that I made and things. You'll love it. You're going to love what I have planned next. Guys, it's just going to take me a while to do it. It's really, really going to be big, and it's really, really going to be good. And you really, really can only see it here because ain't nobody else going to do this. Nobody's going to. Okay. All right, guys. I did not set up OJ, but I will. I don't even know what time it is. Thank you so much for coming out today. Thank you so much. I really, really appreciate it. I'm going to pop on OJ in like 2 minutes, and then I will see you all soon, or I'll see you all later. Have a great day, guys. Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late at night, when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a way, there's no alarm. Freedom tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. Wicked streams, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a way, there's no alarm. Streaming tales waiting to the night. Her laughter feels just right. Even when my world turns gray,